having your deposition taken can be very stressful for a client. Here's some tips on how to do it. Let's start out with a practice question. Do you know what time it is? Answer: yes, it's 11:30. That is a poor way to answer a question at a deposition. It was a yes or no question. The answer is yes. I know what time it is. It's the responsibility of the attorney taking the deposition to ask the follow-up question. Well, what time is it? So let's talk a little bit about the 4 steps to answering a deposition question. First step is listen to the question. Step 2 is think of an answer. Step 3 is answer the question. And step 4 is shut the heck up. You stop. Step 4 is stop talking. So the 2 most often ignored steps to a deposition are steps 2 and steps 4. Often we start answering the question, which is step 3, even before step 1 is completed. We often do that in normal conversation. We speak over one another and each other's sentences. So that pause is very important. Listen for the question mark at the end of a sentence before you answer the question. All right, just doing that alone will aid significantly in you answering the question succinctly. Remember, when we get the deposition transcript, you're paying by the page. So let's try to keep the answers succinct. Here's a common example how someone messes up with step 4. They'll get asked a question about, do you have any information about such and such? And then they'll say, yes. And then they'll explain what information they have. But more commonly, they'll say, no, but I know where to get it. Then they'll explain that information. You know, you're trying to help, and that's great, but let the attorneys do their job, and let's get the deposition done as quickly as possible. It's a little bit different when you're testifying at trial. Obviously, you're going to be prepped by your attorney on how to most effectively communicate the facts. But for the purposes of a deposition, keep it short and sweet, and let the attorneys do their jobs. And this should probably go without being said, but another very, very important thing that you have to do at a deposition is always tell the truth. Don't minimize. Don't try to help your case by changing bits of the story. I mean, just tell the truth. Even a sociopath would want to tell the truth, because telling the truth is actually the best thing for your case. If there's some sort of reason not to tell the truth, then perhaps not answering the question is something to consider. For instance, if it's privileged, if it's something that you're embarrassed about and want to seek a protective order. But those opportunities are very rare and narrow, but it's best to confer with your attorney first if you're confused about whether or not a question should be answered. Have an attorney present at a deposition, even if you're a witness, is often a good idea. Attorneys can protect the interest of the deponent by objecting to information that is privileged, by threatening to stop the deposition and seek a protective order if a question is way out of bounds and not likely to lead to relevant information. Oftentimes, if you're a witness and not a party, the attorney for the party will make those objections, but keep in mind they don't represent you and are not looking out for your interests. So just in summary, step 1 for answering a deposition question is listen. Step 2, think. Step 3, answer. Step 4, stop. You follow those steps, it'll make life a lot easier, you'll be done quicker, and you'll make your attorney a lot happier. Best of luck. A deposition is the opportunity of an attorney to ask questions of a party or witness before a trial. It is used primarily to get information in order to acquire other information later in discovery. One of its most important tools is to put someone's story down firmly so if they change it later, it can be brought to the attention of the judge or jury.